Eviction, or being forced to leave your housing, is one of the hardest challenges anyone could face. But tenants do have rights, and in this video, we will explain the steps you can take to fight this process.
We see landlords engage in illegal evictions by changing the locks on a unit, threatening to call immigration or the police, by shutting off utilities, or going outside the court process in some other way. That is not okay.
There are very specific rules that a landlord must follow before they can force you to move out from your unit. If they don't follow them correctly, you cannot be evicted. These rules apply whether you have a written lease agreement or a verbal agreement with your landlord.
Here we explain the eviction process in 4 parts.
Number 1, landlord serves a notice on you to move out. 2, landlord files an eviction lawsuit. 3, negotiate a settlement or go to trial. And 4, sheriff posts a notice to vacate. But don't worry, you have options at each step, so don't panic. So let's unpack the first step, the notice to move out. To start an eviction, your landlord must give you a valid notice in writing, on paper, telling you to move out. It cannot be a text, email, phone call, or your landlord verbally telling you to move out.
The notice will have a date for when you need to move by. This could be as little as 3 days. Of course, getting this notice is scary, and sometimes people do panic, but you do not need to move right away.
Here are your options. A, move up by the deadline. Only if you want to, you do not have to. Or B, stay and do what the notice says if you can. Sometimes the notice says to pay rent or do something else. C, stay and wait for your landlord to take the next step, which is to file an eviction lawsuit.
As the eviction process begins, it's important to save all your notices and court paperwork. Start a folder and keep everything in one place. Every piece of paper is important and will help an attorney know how to help you.
Step 2, eviction lawsuit. After the move-out notice expires, the landlord files an eviction lawsuit with the court, which is also called an unlawful detainer. The landlord then serves what's called the summons and complaint on you. The summons and complaint and the packet of documents it comes with is the actual eviction court paperwork. This is an important point where you need to take action. You have only 5 court days to file an answer with the court to the summons and complaint.
If you have been served with a summons and complaint, talk to an attorney if you can. If you can't, it's really important to get a bare bones answer filed with the court within the 5 court days. It's better than nothing, because if you don't file an answer, your landlord will win automatically.
After you file your answer, you have 10 days to make any changes.
There are many ways you can challenge the eviction lawsuit and your landlord's side of the story. If you filed a bare bones answer, you can use the next 10 days to add any helpful information and legal reasons why you shouldn't have to move out. Talk to an attorney to help you do this. This is your chance to tell your side of the story and gain some control.
Step 3, trial or settlement. Once you file the answer, the court will set a date for the trial. You have the right to request a trial by jury. We recommend working with an attorney to talk through what options you might have for settling your case or how to prepare for a trial.
The reality is that most cases end in a negotiated settlement and that you do not have to go to trial. The value of a settlement is the opportunity for you to control the outcome and terms of your case. A settlement can look many different ways. It's important to talk to an attorney about your options because it could mean that you get more time to move out or you don't have to pay back rent.
The next step only applies to you if you didn't file an answer to the eviction lawsuit on time, lost your trial, or settled your case, but didn't do the things you said you would do in the settlement. Step 4, sheriff's notice to vacate. A sheriff's notice to vacate is when the sheriff posts a paper on your door stating you have to move out or you will be physically removed.
If you don't move out, the sheriff will often show up with the landlord and a locksmith. The sheriff will order you to leave with only the things that you can quickly gather and carry out on your own that day. But don't wait for the sheriff to show up. If you need more time, you can ask the court for a later move-out date as soon as you receive that first notice from the sheriff.
The request for more time is called a stay of execution.
You must give the court a reason why you cannot move out within the time the sheriff's notice gave you. You also need to pay rent for the time between the date that the sheriff is coming out to evict you and the new move-out date that you are asking for. A stay can give you some breathing room. So talk to an attorney about how to make this request.
So that's it for now. We hope this gives you the basics about the tough situation, and above all, hope you understand that you have options. Remember, don't just move out. Don't ignore court paperwork or your landlord will win automatically. Do pursue all your legal options. An eviction can stay on your record for years.
Remember, it's against the law for landlords to lock out, intimidate, or evict tenants outside of the court process.
Whatever challenges you are facing, know your rights and get help. Call our legal advice line at 800-551-5554 and please use the resources on our website to find more information. We are here to help.